Rule 41A indicates that a plaintiff may have his case dismissed as a matter of right, that is, without permission of any court, at any time before the defendant files his answer or his motion to dismiss. Rule 41A further states that if all parties agree at any point in the litigation, or at any time the court allows it, the case will be dismissed. The rules state that such dismissal will be without prejudice. Rule 41B states that dismissal for failure to prosecute, which means that the plaintiff just simply doesn't do anything for a really long time, or for any dismissal not covered by Rule 41, except for the three that I'll mention in a second, are deemed an adjudication on the merits. Those three exceptions are lack of jurisdiction, improper venue, and failure to join an indispensable party under Rule 19. Dismissal for any of those is not an adjudication on the merits. In addition, we mentioned earlier that dismissal for failure to serve the complaint within 120 days after filing would be deemed dismissal without prejudice. What does all of this mean? What do the terms without prejudice and adjudication on the merits mean? Dismissal without prejudice means that the prior action has virtually no implication going forward. The plaintiff can file exactly the same case again if he wants to. If he does, he may have to pay some of the defendant's fees. This is to prevent people from bringing in and dropping new cases just to be annoying. And additionally, if the case is dismissed a second time voluntarily, he might be barred from bringing the case again a third time. But other than that, the first case materially plays no role going forward. On the other hand, dismissal with prejudice means that the plaintiff is barred from bringing the same case a second time. An adjudication on the merits is a type of dismissal with prejudice. It means that the case is formally decided on behalf of one of the parties and is binding. There are no second chances, and all of the rules relating to res judicata and collateral estoppel are in effect. Why do we have two rules and two drastically different results for basically the same thing? Well, the answer is that they're not the same thing. Dismissal without prejudice is reserved for cases when we want the plaintiff to be able to refile. And some of them it would seem draconian to dismiss the case and then say you can't have a second chance. In others, giving the plaintiff the ability to back out at an early stage when no harm has been done to the defendant and then regroup is actually good for the system because it helps ensure a fair fight. Full litigation, get all the issues out on the table and reach a conclusion. The plaintiff wouldn't want to back out if something had not gone surprisingly and drastically wrong, and that's a good reason to let him do so. Now let's take another look at when dismissal is without prejudice to help see this policy in play. 1, any time before the defendant files an answer or a motion to dismiss. Why do we allow dismissal? Precisely because the defendant hasn't done anything. If he hasn't filed any documents or shown the world his cards about where he stands on the issues, saying never mind at that stage is not going to do him any harm, or very little harm. 2, where all parties agree to the dismissal. By definition, if all parties agree to dismiss the case, it's in the interest of justice to let them do so. Why would we force them to fight when they have no interest in doing so? Typically this happens when the parties have or are about to reach a settlement. It makes perfect sense to let them do so, to let them work it out on their own, and if they decide to dismiss the case while doing so, that's up to them if they want to. Return to the court if they need to later. It seems very silly to force them to fight now rather than let them do so later if that's their choice. 3, if the plaintiff wants to dismiss unilaterally and without prejudice at any other time with the court's approval, and that last point is important. While we technically allow the plaintiff to dismiss it without prejudice even after the defendant objects and the defendant has invested considerable time in the case, the courts as a practical matter are very, very reluctant to do so. When it looks like the plaintiff's objective is to harass, to find a different judge or a different forum, to delay discovery or trial, or to try to change the facts, and do anything else that seems improper, the judge is going to be very, very reluctant to allow dismissal without prejudice. 4, dismissal for lack of jurisdiction, improper venue, or failure to join an indispensable party are all examples of dismissal at a very early stage in the litigation, and for the reason that no proper case has been formed. If we're saying there's no proper case, then dismissing the improper case seems very rational, and it would seem strange to tell the plaintiff, sorry, you messed up your chance, you don't get another one. Finally, failure to serve the defendant within 120 days after filing the complaint simply mean that the complaint and summons expire. Not only has the plaintiff not started the case properly, as a technical matter, the plaintiff never started the case. Nothing's happened, and in most cases, the defendant doesn't even know about the filing. In that instance, it would seem very strange to not give the plaintiff another case when the first dry run never even got off the ground.